If you vote by mail, you need to understand a decision that hasn't been made yet, because whichever way it goes, it will land less than 100 days before the November midterms, and the practical scramble that follows could affect whether your ballot actually reaches you in time. A case called Trump versus California is sitting in front of the Supreme Court right now, unresolved, asking the justices whether a presidential executive order restricting mail-in voting can take effect this election cycle. I'm not going to tell you the court has already decided, because it hasn't, and treating an unresolved case as if it's already settled is exactly the kind of misinformation that leaves voters genuinely confused about what rules actually apply to them right now, today, as they plan how they're going to cast their ballot this fall. What I am going to do is walk you through exactly what's at stake for you as a voter depending on which way this breaks, the compressed timeline everyone involved is now racing against, and what you should actually be watching for in the coming days. Before we get into it, if you want to actually understand the practical stakes of a pending case instead of just waiting for a headline to tell you what happened after the fact, subscribe and turn on notifications right now. This is exactly the kind of story where understanding the timeline before the ruling drops matters as much as understanding the ruling itself, because the practical steps you might need to take look different depending on which outcome actually happens. Let's get into what's actually on the table. Here is the plain language version of what's being fought over. President Trump signed an executive order on March 31, 2026, directing the Postal Service to develop new rules for handling mail-in ballots, tied to citizenship verification lists the Department of Homeland Security would compile state by state. Under the framework, the order envisions the Postal Service would only deliver mail ballots to voters confirmed on these citizenship lists. 23 states and the District of Columbia sued, arguing the president doesn't have the constitutional authority to unilaterally reshape how mail voting works nationwide. A federal judge blocked the order in those states in June. Two different federal appeals courts then reached opposite conclusions on essentially the same order within days of each other in late July, which pushed the fight to the Supreme Court on an emergency basis. As of right now, the justices have the case, briefing just closed, and no ruling has been issued. The first segment is what happens if the Supreme Court sides with the administration and allows the order to take effect. Even in this scenario, election law specialists have been clear that the practical rollout faces serious obstacles regardless of the legal outcome. The Postal Service itself told the courts in July filings that it is running out of time to actually implement citizenship verification and ballot interception rules in time for a November 3rd election, meaning even an immediate green light from the Supreme Court might not translate into fully operational new rules by Election Day. Building a functioning state-by-state citizenship verification system from scratch, one accurate enough to avoid wrongly excluding eligible voters, is the kind of large-scale technical and administrative undertaking that typically takes agencies many months or years to build and test properly, not the handful of weeks that would remain even under the fastest possible timeline here. If partial implementation does happen, voters in the 23 states that sued, plus D.C., would be the ones most directly affected, since those are the specific jurisdictions where Judge Talwani's injunction has been blocking the order. If you live in one of those states and vote by mail, this is the scenario where you'd want to pay closest attention to your state election office's guidance in the weeks immediately following any ruling, since local election officials would be the ones actually implementing whatever the Postal Service and DHS ultimately require. And they would likely be the first, most reliable source of practical guidance about what specifically changes for your own ballot. The second segment is what happens if the Supreme Court denies the administration's request and leaves the injunction in place. In this scenario, mail-in voting in the 23 challenging states and D.C. would continue operating under existing rules for this November's election, without the new citizenship list requirement, while the underlying legal fight over the executive order's constitutionality continues working through the normal appeals process rather than the emergency track. This wouldn't necessarily be the final word on the order's legality either, since a denial of emergency relief is a different legal question than a final ruling on the merits, meaning the broader legal fight could still continue for months or years after this specific emergency phase concludes, potentially resurfacing again before a future election cycle even if it doesn't affect this one. The third segment is the states not currently part of this specific lawsuit, because the scope of this particular case is genuinely narrower than the phrase nationwide implications might suggest. This case specifically involves the 23 states and D.C. that sued in Massachusetts, plus a separate group of 12 states led by Alabama that filed a brief supporting the administration. If you live in a state that isn't part of either group, the direct legal effect of whatever the Supreme Court decides here may be less immediately clear, since the injunction currently in place only covers the states that actually sued. Separately, a related executive order addressing overlapping citizenship and ballot deadline issues was already blocked specifically in Washington and Oregon by a different federal judge back in January, meaning the overall legal landscape governing this general policy area varies meaningfully depending on which specific court order applies to which specific state. A genuinely confusing patchwork that even election law experts have had difficulty summarizing cleanly. The fourth segment is the specific practical risk both sides have raised, worth understanding regardless of which side you find more persuasive. The 23 challenging states have specifically warned that citizenship verification systems of the kind DHS would need to build quickly are known to generate false positives, meaning legitimately registered, eligible citizens could be mistakenly left off the list and have their mail ballots withheld. A concern the states specifically raised as disproportionately affecting voters with disabilities and those in rural areas who rely most heavily on mail voting in the first place. The administration's counterargument has generally emphasized that the underlying goal, ensuring only confirmed citizens participate in federal elections, is itself a legitimate government interest, and that concerns about implementation details shouldn't block the policy from being tried at all. If you vote by mail and you're concerned about this possibility, the most useful thing you can do isn't panic in advance of a system that may or may not ever get implemented. It's knowing your own state election office's contact information and understanding your state's specific process for confirming your registration status if you ever have reason to be concerned, regardless of how this particular federal case resolves. The fifth segment is the realistic timeline you should actually expect, because emergency Supreme Court applications don't follow a fixed schedule the way a normal case does. Now that both sides have filed their arguments, the court can act at any time, sometimes within days of full briefing closing, sometimes longer if the justices want additional time to consider a genuinely close or complicated question. Given the tight timeline before November, most court watchers following this case expect a ruling relatively soon rather than months from now, precisely because a decision that arrives too close to the election would itself create additional chaos regardless of which way it goes. That said, predicting an exact date is genuinely not possible, and treating any specific date as certain before it's actually confirmed is exactly the kind of premature claim that's already caused confusion around this case. The sixth segment is what to actually watch for as reliable signals that a ruling has happened, since this is exactly the kind of case where misinformation is likely to spread the moment something does happen. The most reliable sources for confirming an actual Supreme Court ruling are the court's own website, which posts orders and opinions directly, along with established legal reporting outlets that specifically cover the court's docket in detail. If you see a claim that the Supreme Court ruled on this case, the fastest way to verify it is checking whether the claim includes specific, verifiable details, the actual vote count, which justice or justices wrote for the majority, and what the order specifically says the lower court ruling must now do, because vague, dramatic headlines without those specifics are often exactly the kind of premature or entirely fabricated claims that have already circulated around this case before any actual ruling existed. Let's step back and name what actually matters most heading into whatever ruling eventually comes. This case will resolve one specific, narrow emergency question: whether this executive order can take effect while the broader legal fight over its constitutionality continues, not necessarily the final word on whether the order is lawful at all. Regardless of which way it breaks, the practical reality facing election officials, the Postal Service, and voters themselves involves genuine logistical constraints that exist independently of the legal outcome, meaning even a clear ruling in either direction won't necessarily translate into a clean, simple change on the ground, given how little time remains before November. It's worth acknowledging directly why this specific case has generated so much premature commentary and outright speculation online, because understanding that pattern helps you navigate it better going forward, not just for this case, but for the next major pending ruling you encounter. Election-related Supreme Court cases combine genuine legal complexity with intense, immediate political stakes, a combination that creates strong incentives for content creators on every side to get ahead of the actual outcome, sometimes through honest confusion about a fast-moving story, sometimes deliberately because a dramatic claim about a ruling that hasn't happened yet generates attention regardless of whether it's accurate. The antidote isn't avoiding this kind of story until it's fully resolved. It's holding two things in your head at once: real, informed understanding of what's actually at stake and what both sides are genuinely arguing, alongside honest acknowledgement of what remains genuinely unknown until an actual ruling exists. If you take one thing away from this breakdown, let it be this. When a case this significant is still pending, the responsible thing to do is understand the stakes on both sides of the possible outcome, not assume or repeat a result that hasn't happened yet. Whatever this court decides, it's going to matter enormously for how this November's elections actually run, and you deserve to understand that decision accurately the moment it's real, not a version of it manufactured in advance by someone chasing views before the actual facts exist. If this helped you understand what's genuinely at stake before the ruling comes down, share it with someone who's already seen a premature claim about this case. Subscribe so you get the real ruling explained the moment it's official, and I will see you the moment this actually resolves.